Day tomorrow, the ANC SG Ace Magashule makes his first court appearance on corruption charges, all relating to a 255 million rand Free State asbestos audit contract signed when he was Premier. Here's the question. How difficult, some are asking, is it going to be to prove the charges against him? Let's give you a first view as I'm talking now to criminal lawyer Ulrich Roux. Ulrich, good afternoon to you. The Prevention and Combating of Corrupt Activities Act are a failure to report a criminal offence and directly or indirectly accepting gratification for their or another person's benefit. That's essentially the nub of the charges. What does the state have to prove, and how difficult do you think it's going to be?
Hi, good afternoon. Well, I think we must look at what the charges emanate from, and that is, of course, the very infamous now asbestos deal, where a 255 million rand tender was awarded to a company owned by Mr. Edwin Sodi, and where it in fact then transpired that none of the work that was supposed to be performed, or very little of it, was in fact performed, and that there was large-scale corruption taking place, which resulted in these funds being paid out not only to private individuals, such as Mr. Sodi, which is the allegation, but also to government officials. And that is where Mr. Magashule comes into play. There's allegedly some evidence that he has been awarded 10 million rand of that tender deal, and that was in return for him awarding the deal to Mr. Sodi's company. So when a person is charged with corruption, fraud, money laundering, racketeering, then you always need to follow the paper trail, and that is the most important thing. So if it can be shown that certain funds flowed from certain bank accounts and went to people who were not entitled to those funds, and in return for that, they were, for instance, awarded tenders, such as what is the case in this instance, then, that's a starting point to prove these cases. But it is a very technical charge to prove, in the sense that you do rely on hard evidence, not only testimony led by witnesses, but the actual flow of funds must be identified and must be shown to a court, and it must be shown beyond a reasonable doubt that those funds were in fact transferred to the people accused with the crime, and that they benefited from it unlawfully so.
To your point, then, it is going to rely on strong testimony from witnesses, but there are some suggestions today that those witnesses will either be hard to find or would be loath to come forward.
Well, I don't think we must put the cart before the horse at this stage. It is clear that, a lot of evidence has come out of the state capture inquiry, and that the Hawks have been probing this matter and investigating this matter for, a long time now already. We saw the earlier arrest of Mr. Sodi and his associates, and I think that we must, the society can feel at ease that the arrests are only made once the police and once the state is in possession of sufficient evidence. So if people had to come and testify against these accused now in this matter, then they would only be able to do so if they have already deposed to an affidavit under oath, right, which implicates these people. And accordingly, they will then, show their willingness to come and testify if they did, in fact, make that affidavit. So I don't think we must preempt this at this stage already. Let's see how things unfold. And then if the matter is set down for trial, hopefully those witnesses will come forward.
Spoken like a true attorney. Just one last question. How would the SG then mount the best defense? Could he cry ignorance and say this was done by others without my knowledge at all?
Well, if it can be proven beyond a reasonable doubt that he derived a benefit from this, then that would be very difficult indeed. And unfortunately, ignorance of the law is never a defense. So, I would be surprised if that is going to be his defense, if he ever takes a stand. But, as any other accused person, he would be given an opportunity to have sight of the docket, so in other words, all of the evidence that the state has against him, and then to prepare his defense accordingly. And, I've said it so many times, but remember that the state, the onus on them is to prove a case beyond any reasonable doubt, so there can be no doubt that the accused people did commit the crime which they are being accused of, whereas his version, Mr. Magashule, as well as his co-accused, must only be reasonably and possibly true. in order to be accepted by a court. And that is the balancing act that the court will have to make. If, for instance, as you say, he says, well, I never knew that this was wrong, then the court will definitely make a credibility finding on him. And certainly if a person, in accordance with the allegations, receives 10 million rand in order to ensure that a tender is awarded to a certain company, then, it would be hard to believe that he didn't know that there was something wrong about that.
All right, as you say, though, let's not put the cart before the horse. That is criminal lawyer Ulrich Roux. Thank you very much indeed. eNCA will have a strong live presence outside the court in Bloemfontein from around 6 o'clock tomorrow morning.